So today, if I were to go get a building permit, is there a way to protect my future warrantless searches by signing under duress? Or there was a card handed out at the last admin code meeting that we did that, we could sign, we had to sign it, like if we got a speeding ticket, you have to sign it, but you can sign it under duress, and then you're not agreeing that you're guilty, you're just getting your car back.
Yeah, and Washington's one of the states that allows people to accept a permit under protest, because it is the inspection, the inspection requirements, the deemed consent requirement is an unconstitutional condition. It's causing you to waive your right to privacy in order to get a permit. So you can sign it under protest and say that by accepting this, you're not agreeing to warrantless inspection of the property.
Okay, and then when you mentioned your blog at the end, are you going to give us that information? So, because I'm sorry, but I don't know if anybody from the press is here, but our local press doesn't tell us anything. And if they ever tell us anything, it's already occurred and we can't do anything about it, or we go to court or whatever. And so it'd be really nice to find a way to follow what's going on.
Yeah, well, you can link to it either through our main page at pacificlegal.org. We have a link directly to, it's called the Liberty Blog, or if you just Google PLF Liberty Blog, will be the first hits.
Thank you.
Yeah.
I'm kind of curious about second-class tidelands and how they relate to buffers. Are they private property anymore? I'm a retired land surveyor, and with Bolt's decision and the rest of it, and the DNR and all the people involved, what are second-class tidelands private property?
And you're probably also including like patented property as well. Because they're the land patents, Washington, early land patents that included shorelines. The problem is that that's a legal distinction that the courts are ignoring.
Well, they can't.
Yeah. They're treating all shorelines the same. They're imposing public trust obligations. For those who don't know, the public trust was a doctrine that was supposed to protect the right-of-way in water for navigation and fishing and stuff like that, so that shoreline property owners couldn't interfere with the public's traditional use of water. There are some shorelines, and we have a very strange system in Washington, but there are some shorelines where owners actually own out into the water.
Yeah.
The courts used to, up until the 70s, they used to really respect these definitions and provide. We had a patchwork of different rights along the shoreline, but that's the way it was. That's what people purchased, and that's what they owned.
Second-class tidelands were part of the parcel.
Yeah.
Used to serve it.
Yeah. Current courts are looking past it. It's just like the water rights. We used to operate under prior appropriation doctrine that says that if you had established water rights, you had senior rights, and they didn't divvy it out. You just had senior rights. They've been replacing it with ecology regulations to get rid of those vested rights.
A couple of big items that I've seen, certainly from the perspective of tax shelters, if you will, for wealthy individuals, are, as you referenced earlier, conservation easements, and the other one is historic facade easements of historic buildings, things of that nature. In this situation, as I understand, a lot of times the historic or the conservation easements are granted to the federal government. And in those types of situations, especially where you have enormous, large tracts of wilderness land, if that restricts the use from any other kind of economic use, how does that really invalidate any economic value to the? Are there any other rights that attach to that to somebody who would inherit or purchase the land subject to that conservation easement? Because as I understand, it's in perpetuity as well. So.
Yeah, typically conservation easements are permanent. There are many different situations where you'll find conservation easements. Sometimes large property owners will carve off a portion of their property to trade it for more intense development on the favored parcel. You see that a lot with big developments they'll create parks or they'll create a little critical area in order to mitigate for any of the harms of the larger development. So yeah, that parcel that goes into the conservation area is forever. Other circumstances are when it's just a strip across somebody's property, and that's where it becomes a little more difficult to say, you still have the rights that you use the rest of the property to develop the rest of the property. They're more circumspect now because of the imposition of a buffer.
The issue comes in the category of buffer averaging. They'll grant a waiver to bring a house or construction within the buffer down to 35 feet or 45 feet of a stream, where the normal setback would be, say, 100 feet. In order to grant that forward movement of the building, they're demanding buffer averaging, which means you have to give additional property back here beyond the 100 feet, which may be on the back downslope on the other side of the hill. No relationship to what they're intending to protect. Nolan?
Well, common sense first, but
they wouldn't go with that.
I know, sadly, if only. That's just absurd because there are the rules that say that buffers can't jump roads. That you've got an intact buffer. Let's give them the benefit of the doubt. Say it is an area that needs a buffer, that buffer has to be intact for it to work, which means that you can't interrupt it with impermeable surface area or something else that's going to stop the process of, for example, with water quality buffers, the filtration of pollutants out of stormwater. If you're putting the buffer behind the house, it's not going to work because it's not going to provide any benefits.
Oh, that's right.
It's a failure. I would start with a failure of science, and then, yeah, it would go to Nolan Dolan. Of course, we need to respond to that Division 1 case, Common Sense Alliance, that sort of short-circuited our path of having these demands subjected to meaningful scrutiny.
Well, the other part of the question that comes, if you can put the house within 35 feet of the water body, is the buffer required to be 100 feet?
Yeah.
And we have lots of examples of pre-existing buildings that are quite close to water. When this whole thing started, it was very interesting. 3 county commissioners sat at the dais and they said, we've had a 35-foot setback, they call it a setback, in Kitsap County forever. We've never seen a problem. So now we have existing buildings, old buildings. We're getting no proof of harm from those buildings. Is there any carry forward on that?
Again, that's just more evidence on the failure of science. And the idea that you can average buffers and that they can achieve this no net loss, which is a standard for shoreline regulation now, which is supposed to mean that any impacts that you may have on the environment can be mitigated. If you can do that, if you can move the buffer up to 35 feet when the mandatory one's 100, it's sort of an emperor has no clothes moment, because was there ever a reason for being at 100 if 35 is enough to protect the environment? If other voluntary mitigation measures will make that appropriate.